Case 1, Karla Garcia. Hartford County, Connecticut. September 19, 2024. There are moments in a criminal investigation when the evidence gathered by law enforcement tells a story that is not about a single decision made in a moment of crisis. There are cases where the record assembled by investigators, forensic specialists, and prosecutors points to something different. A series of choices made over an extended period of time, each one documented, each one forming a link in a chain that would eventually bring a case before Hartford County Superior Court and into the permanent record of Connecticut's judicial system. The case of Karla Garcia is one of those cases. It is a case built on court documentation, law enforcement findings, and the patient investigative work of Hartford County authorities. And at its center is a child named Jacqueline Torres Garcia, known to those who loved her as Mimi, who was 11 years old. Mimi Torres Garcia lived in the New Britain and Farmington area of Hartford County, Connecticut. She was a child navigating the world the way 11-year-olds do, old enough to have a personality, old enough to have preferences and a sense of humor, old enough to begin forming her own understanding of who she was and where she belonged in the world. She was also, in the most fundamental legal and moral sense, a child in the care of adults who were responsible for her safety, her nourishment, and her well-being. Those adults were her mother, Karla Garcia, and Garcia's boyfriend. Together, according to the prosecutorial record established in Hartford County Superior Court, those two adults made decisions in the weeks leading up to September 19, 2024, that investigators would later document in exhaustive detail. The investigation into what happened to Mimi Torres Garcia was initiated when Hartford County law enforcement became aware that the child had lost her life. What followed was a thorough forensic and investigative process involving multiple law enforcement agencies, forensic specialists, and the full resources of the Hartford County State's Attorney's Office. The findings that emerged from that investigation were extensive, carefully documented, and serious enough to result in some of the most significant charges available under Connecticut criminal law. Among the most consequential findings in the investigative record was the determination that Mimi Torres Garcia had been denied adequate nutrition for a sustained period prior to her passing on September 19, 2024. According to court documents and information confirmed by NBC Connecticut and additional regional news organizations covering the Hartford County proceedings, investigators established that the child had not been provided with sufficient food for approximately 2 weeks before her death. This determination was supported by medical and forensic evidence presented as part of the evidentiary record in Hartford County Superior Court. Prosecutors established to the court's satisfaction that this was not a situation arising from economic hardship or an inability to access necessities. The record reflects a deliberate course of conduct by the adults in whose care Mimi was placed. Following her passing on September 19, 2024, her death was not reported to authorities. According to the charging documents filed in Hartford County, investigators determined that her remains were concealed within a plastic storage container inside the household. It was this concealment, combined with everything else the investigation had revealed, that informed the scope and seriousness of the charges ultimately brought against Karla Garcia. The charges filed against Garcia in Hartford County Superior Court reflect the thorough assessment that prosecutors brought to this case. She was charged with murder with special circumstances, a charge that in Connecticut carries the most severe penalties available under state law. She was also charged with conspiracy to commit murder, reflecting the prosecutorial finding that the conduct leading to Mimi's passing involved coordinated action between Garcia and her co-defendant rather than unilateral action by one individual. Garcia was further charged with intentional cruelty to a child, a charge applied when the evidence establishes a pattern of deliberate harmful conduct toward a minor in one's care. The charging document also included a count of unlawful restraint, connected to investigative findings regarding the child's access to movement and assistance during the period under examination. And finally, Garcia was charged with concealment and improper disposal of a human body, directly addressing the circumstances in which Mimi's remains were discovered. The breadth of the charging document in this case is significant. Hartford County prosecutors did not bring a single charge and rest on it. They systematically identified each element of what the investigation had established: the deprivation, the restraint, the concealment, and applied a specific criminal charge to each element. This approach reflects the seriousness with which the Connecticut State's Attorney's Office treats cases involving child victims, and it ensures that the full scope of what the investigation revealed is reflected in the permanent court record. For the communities of New Britain and Farmington, the case raised important and difficult questions about the systems that are designed to detect harm to children in private settings. Child welfare advocates who spoke publicly in the aftermath of the investigation noted that cases involving harm to a child within a household over an extended period are among the most challenging for external systems to identify, because the harm is occurring in a private space and the child is typically unable to seek assistance independently. The fact that Mimi Torres Garcia was 11 years old, of school age, old enough to potentially have contact with teachers, counselors, neighbors, and other community members, made the circumstances of this case particularly significant from a child protection policy perspective. The question of what could have interrupted the chain of events before September 19, 2024, is one that Connecticut child welfare institutions continue to examine. At the time this documentary was produced, the proceedings against Karla Garcia were continuing through Hartford County Superior Court. The presumption of innocence remains in place for the defendant as the legal process proceeds. What is established and documented in the court record is this. A child named Jacqueline Torres Garcia, known as Mimi, was 11 years old and living in Hartford County, Connecticut. She was owed protection, care, and love by the adults in her life. The court proceedings in Hartford County are now her voice, and the Connecticut criminal justice system is carrying that voice forward on her behalf. Connecticut's child welfare organizations, including the Department of Children and Families, maintain resources for reporting concerns about a child's safety. If you are aware of a child who may be at risk, please contact the appropriate authorities in your community. Every report has the potential to save a life. If this case moved you and you believe that Mimi's story deserves to be heard, please take a moment to like this video and leave a comment below. Subscribe to Cold Case Hours so you never miss a new documentary. Your support keeps this work going. Don't forget to like and subscribe. Case 2. Karin Ziolkowski. New Haven County, Connecticut. November 14, 2016. New Haven County, Connecticut, has one of the most active and experienced court dockets in the state. Its prosecutors have handled cases of significant complexity over many decades, and the county's court system is equipped to process the most serious criminal matters that arise within its jurisdiction. When investigators in the city of Meriden, Connecticut, responded to a call on the evening of November 14, 2016, they encountered a scene that would require the full investigative capabilities of the Meriden Police Department and the forensic expertise of the State Medical Examiner's Office. The case that emerged from that investigation would be prosecuted in New Haven County Superior Court under charges that told a story fundamentally different from what first responders encountered when they arrived at that Meriden address. The child at the heart of this case was Elijah Ziolkowski. He was 8 years old, an age of curiosity, of school friendships, of the particular energy that belongs to second and third graders who are learning that the world is larger and more interesting than they had previously understood. He was the son of Karin Ziolkowski, and he was living with her in their Meriden home in the fall of 2016. What happened to Elijah on November 14th of that year, and what the investigation subsequently established about the events of that evening, became the foundation of a serious criminal prosecution in New Haven County Superior Court. When fire crews and emergency personnel arrived at the Ziolkowski home in Meriden on November 14, 2016, they encountered an active residential fire. Elijah was found at the scene and had not survived. Initial response protocols were followed, but it was the medical and forensic examination conducted in the hours and days that followed that shifted the nature of the case from a fire emergency into a criminal homicide investigation. The medical examiner's findings were precise and decisive. The examination of Elijah Ziolkowski established that the child's cause of passing was asphyxiation, a finding that was entirely independent of the fire at the home. The medical examiner's determination was that Elijah's death was a homicide. This finding had profound implications for the entire investigation because it established with medical and forensic certainty that Elijah had lost his life before the fire began. The fire, in the forensic framework established by the investigation, was not the cause of what happened to Elijah. It was what came after. This forensic sequence, the establishment of cause of passing first and the fire investigation second, shaped the charging decision made by New Haven County prosecutors. Two separate criminal charges were filed against Karin Ziolkowski in New Haven County Superior Court. The first was a charge of murder under Connecticut criminal statutes, reflecting the medical examiner's homicide ruling and the investigative findings that followed from it. The second charge was second-degree arson, a serious felony charge under Connecticut law, applied in circumstances where a fire is deliberately set. The arson charge, in the prosecutorial theory of this case, was inseparable from the murder charge. Prosecutors presented these two charges as documenting two sequential acts, the first resulting in the loss of Elijah's life, and the second representing an attempt to alter the evidence and circumstances of what had occurred inside that home. The prosecution of Karin Ziolkowski moved through New Haven County Superior Court with the full engagement of the state's attorney's office. The evidentiary record rested on several pillars: the medical examiner's unambiguous findings establishing cause and manner of death, the forensic fire investigation establishing the intentional nature of the fires set in the home, and the investigative work of Meriden law enforcement connecting those forensic findings to the charges against the defendant. Court documentation published through CT.gov and coverage by the New Haven Register and the Hartford County tracked the case through the New Haven County court system. What distinguishes the Ziolkowski prosecution from cases involving a single criminal act is the sequential nature of the conduct that prosecutors alleged. The charging document tells a two-chapter story: what happened to Elijah and what happened next. Each chapter corresponds to a criminal charge. Together, those charges reflect the full scope of what the investigation established about that November evening in Meriden in 2016. The community of Meriden, Connecticut, is a mid-sized New Haven County city with a strong sense of neighborhood identity. Cases of this kind, particularly those involving young children, affect Meriden's community institutions, schools, and family networks in ways that extend far beyond the courtroom proceedings. Child welfare advocates in New Haven County consistently point to cases like the Ziolkowski prosecution as documentation of the importance of maintaining robust reporting and response systems for child safety concerns. The forensic work that brought this case to justice required sophisticated scientific analysis. The human work, the attentiveness of communities to the children within them, requires something available to everyone. Elijah Ziolkowski was 8 years old. The fire that investigators say was set in his home might have obscured what truly happened to him. The science of forensic investigation and the commitment of New Haven County prosecutors to following the evidence where it led ensured that it did not. His case is part of the permanent record of New Haven County Superior Court, a record that documents both the tragedy of his passing and the legal accountability that Connecticut's justice system pursued in his name. Don't forget to like this video and subscribe to Cold Case Hour. Every subscription helps us continue bringing these important stories to the public. Hit that subscribe button now and turn on your notifications. Case 3. Crystal Czyzewski. New London County, Connecticut. November 17, 2021. There is a particular weight that attaches to cases involving the youngest victims in any criminal justice system. Cases where the victim's age is measured not in years, but in weeks. Cases where the law must speak on behalf of someone who never had the opportunity to speak for themselves, who never took a first step, who never formed a first word, and who never had the chance to become the person they were meant to be. The case of Crystal Czyzewski, processed through New London County Superior Court following events in the town of Griswold on November 17, 2021, is one of those cases. New London County occupies the southeastern corner of Connecticut. It is a region of smaller communities, rural landscapes, and a county court system that serves a population spread across a wide geographic area. Griswold is a quiet town in that region, a community of modest size where the arrival of a serious criminal case in the court docket is noticed and felt by residents in ways that the larger urban counties sometimes do not experience in the same immediate way. When the investigation into the passing of Crystal Czyzewski's infant son came before the New London County court system in the fall and winter of 2021, it brought with it the full gravity of a case involving a victim who had been in the world for only 6 weeks. 6 weeks of life. That is the age of the infant at the center of this case. He was Crystal Czyzewski's son, and he was, by every medical and legal standard applicable to a human being of his age, entirely and completely dependent on his mother for his survival. A 6-week-old infant cannot regulate his own temperature, cannot feed himself, cannot move to safety, and cannot communicate distress in any way that does not require an attentive and caring adult to interpret and respond. His vulnerability was not partial. It was total. In Connecticut law, through the specific criminal statutes that govern cases involving infant victims, recognizes and reflects that total vulnerability in the penalties and charges it makes available to prosecutors. The investigation into the infant's passing was conducted by Griswold Law Enforcement with the involvement of the new London County State's Attorney's Office. What made this investigation distinctive from a procedural standpoint was the presence of a critical evidentiary element that is not always available to investigators in serious criminal cases: a statement from the defendant herself. According to the court record established in New London County Superior Court and confirmed by regional news organizations including the Norwich Bulletin and CT Insider, Crystal Czyzewski made admissions to law enforcement investigators in the course of the investigation into her son's passing. Those admissions were specific, detailed, and directly relevant to the charges subsequently brought against her. According to the prosecutorial record in New London County, Czyzewski told investigators that on November 17, 2021, she placed a blanket over the face of her 6-week-old son and held it there for an extended period. The duration described in the investigative record was approximately 20 minutes. The medical findings in the case were consistent with and supportive of the account contained in those admissions. The cause of the infant's passing was established through the medical examiner's investigation, and those findings aligned with the circumstances described in Czyzewski's own statements to law enforcement. The charges filed against Crystal Czyzewski in New London County Superior Court reflected both the seriousness of the medical and investigative findings and the legal framework that Connecticut prosecutors apply in cases involving infant victims. She was charged with first-degree manslaughter, a serious felony under Connecticut criminal law that reflects a finding of intentional conduct causing the loss of life of another person. She was also charged with risk of injury to a child, a charge that captures the conditions and circumstances to which the infant was subjected on November 17, 2021. Together, these charges documented, in the language of Connecticut criminal law, the full scope of what the investigation had established. The case resolved through a formal guilty plea entered by Crystal Czyzewski in New London County Superior Court. In Connecticut criminal procedure, a guilty plea represents the defendant's formal acknowledgement before the court of the essential facts supporting the charges against them. The entry of that plea in this case created a permanent legal record in New London County, a record that acknowledges, in the most formal way that the legal system provides, what the investigation had established about the events of November 17, 2021, in Griswold. From an evidentiary standpoint, the Czyzewski case illustrates a dynamic that investigators and prosecutors sometimes encounter in cases where the defendant's own statements become a central pillar of the court record. The admissions made by Czyzewski to investigators were consistent with the physical and forensic findings in the case, and that consistency contributed to the resolution of the matter through a guilty plea rather than a contested trial. The New London County court system processed this case with efficiency and seriousness, and the outcome reflects the commitment of Connecticut's criminal justice apparatus to achieving accountability in cases involving the most vulnerable victims. Child welfare and infant safety organizations throughout Connecticut point to cases like the Czyzewski prosecution as reminders of the importance of support systems for new parents experiencing crisis. Postpartum mental health resources, family support networks, and crisis intervention services exist specifically to provide assistance to parents who are struggling with the overwhelming physical and emotional demands of caring for a newborn. The Connecticut Department of Children and Families maintains a 24-hour hotline for families in need of support and for community members who have concerns about a child's safety. The existence of those resources represents a collective commitment to intervening before a family reaches a point of crisis from which there is no recovery. The infant son of Crystal Czyzewski was 6 weeks old. He had 6 weeks of life. The New London County Court record preserves, in the permanent documentation of the legal system, the findings of the investigation into his passing, and the formal accountability that Connecticut's courts established on his behalf. His story is part of the record of justice in New London County, Connecticut, and it is a story that this community, and every community that cares about the safety of its youngest and most vulnerable members, deserves to know. Don't forget to like this video, leave a comment, and subscribe to Cold Case Hour. These infants deserve to be remembered. Your subscription is how you help us make sure they are. Hit that subscribe button right now. Case 4, Tabitha Frank. Hartford County, Connecticut. July 6, 2023. Hartford, the capital city of the state of Connecticut, is a city that has seen its share of serious criminal proceedings move through the dockets of Hartford County Superior Court. The court's prosecutors are experienced, its investigative partnerships with Hartford law enforcement are well established, and its institutional capacity to handle cases of significant legal complexity is among the strongest in the state. When the events of July 6, 2023, were brought to the attention of law enforcement and subsequently to the Hartford County State's Attorney's Office, the case that developed was one that tested an important and often misunderstood area of Connecticut criminal law. The area that addresses not deliberate acts of physical harm, but the criminal consequences of choices that place children in conditions where serious harm becomes not just possible, but foreseeable. The case of Tabitha Frank is a case about criminal negligence. It is a case about the legal standard that Connecticut places on every adult who takes on the responsibility of caring for young children, and about what happens under Connecticut law when that standard is departed from so severely that a child loses their life as a direct consequence. It is not a case of deliberate physical violence in the traditional sense. It is something that child welfare advocates and legal professionals sometimes argue is equally important to prosecute with seriousness, because the principle it enforces is foundational to the safety of every vulnerable child in the state. The victim in this case was a 2-year-old boy, the son of Tabitha Frank. He was a toddler at the most energetic and exploratory stage of early childhood development, walking, running, climbing, curious about every surface and opening and object in his environment, and entirely incapable of recognizing or responding appropriately to physical dangers. A 2-year-old child does not understand the concept of height. A 2-year-old child does not understand what a window opening at a significant elevation represents in terms of physical risk. A 2-year-old child navigates the world through curiosity and physical exploration, and the responsibility for ensuring that the physical environment in which that exploration occurs is safe falls entirely and unambiguously on the adults charged with that child's care. On July 6, 2023, Tabitha Frank left several young children, including her 2-year-old son, without adult supervision in an apartment in Hartford, Connecticut. The conditions of that apartment and the specific physical circumstances that existed within it during the period of unsupervised access were documented by Hartford law enforcement investigators and presented to the court in the charging documents filed against Frank. Among those conditions was access to a window on the 3rd floor of the building in which the apartment was located. During the period in which the children were without adult supervision, Frank's 2-year-old son reached that 3rd floor window. He fell from it. The medical consequences of a fall of that distance for a child of that age were severe and ultimately unsurvivable. He was transported to a medical facility where emergency personnel provided treatment, but the injuries he had sustained in the fall were beyond what medicine could repair. He did not survive. The Hartford County Medical Examiner and investigative record established the direct causal connection between the unsupervised conditions in that apartment, the accessible 3rd floor window, and the child's fatal fall on July 6, 2023. Hartford law enforcement and child welfare investigators worked together in the aftermath to build the evidentiary record that would form the basis of the criminal charges against Tabitha Frank. Prosecutors in Hartford County charged her with first-degree manslaughter with reckless disregard, a charge that reflects a legal finding that the defendant's conduct demonstrated a reckless disregard for human life, and that this recklessness directly caused the loss of the child's life. The charge of risk of injury to a child was also filed, capturing the conditions under which the children had been left. Criminal neglect, the 3rd charge in the indictment, addressed the broader documented failure of duty of care. The legal framework in the Frank case is worth examining carefully because it reflects an important principle in Connecticut criminal law. The state does not require prosecutors to prove that a parent intended to harm their child in order to bring serious criminal charges in connection with a child's death. Connecticut's manslaughter statutes recognize that reckless conduct that demonstrates a conscious disregard of a substantial and unjustifiable risk, can meet the threshold for serious criminal accountability when that conduct results in the loss of a child's life. The Frank prosecution represents Hartford County's application of that principle to the documented facts of July 6, 2023. Regional news organizations including NBC Connecticut, WFSB, and the Hartford Courant covered the case as it moved through Hartford County Superior Court. And the community response in Hartford reflected both the grief that attaches to any child's passing and the broader questions that the case raised about child supervision standards and the systems that exist to monitor and support families with young children in the state's capital city. Child safety advocates consistently note that cases like the Frank prosecution serve an important public awareness function beyond the specific matter of individual accountability. They remind communities, caregivers, and child welfare institutions that the physical environments in which young children are left, even temporarily, even in familiar settings, carry risks that require adult attention and mitigation. Window guards, door barriers, and the elimination of unsecured access to elevated openings in homes with toddlers are among the basic safety measures that child safety organizations promote precisely because the consequences of their absence can be swift, irreversible, and fatal. The 2-year-old son of Tabitha, Frank, deserved a safe environment. He deserved the supervision and protection that the law requires every caregiver to provide. Hartford County Superior Court processed his case with the seriousness that his short life demanded. The court record in Hartford County is a permanent acknowledgement both of what was lost on that July afternoon in 2023 and of the legal accountability that Connecticut's justice system pursued in response. Don't forget to like this video and subscribe to Cold Case Hour. Share this documentary with someone who cares about child safety and true crime justice. We release new content regularly, and your subscription ensures you never miss a case. Subscribe now. Case 5, Devoni Miller, Middlesex County, Connecticut, September 11, 2023. The Connecticut River is one of the defining natural features of the New England landscape. It runs the full length of Connecticut from north to south, passing through cities and towns that have built their identities around its presence for centuries. In Middlesex County, the river borders several communities and has long been a feature of the daily life of the region's residents. On September 11, 2023, the Connecticut River became the setting for a law enforcement investigation in the town of Cromwell, an investigation that involved multiple agencies, a vehicle crash, and the loss of a toddler's life in circumstances that Middlesex County prosecutors would bring before the court system under the most serious charges available in Connecticut criminal law. Cromwell is a town in Middlesex County positioned along the western bank of the Connecticut River. It is a community of moderate size with the kind of residential character that typifies many of the towns in Connecticut's Central River Valley region. The events of September 11, 2023, began not at the river but on the roads of Cromwell, where Devoni Miller was involved in a vehicle crash. That crash, and what happened in the time that followed it, became the subject of a detailed multi-agency criminal investigation whose findings were ultimately brought before Middlesex County Superior Court. Miller's toddler was with her at the time of the crash. Following the collision, rather than remaining at the scene and accessing the emergency response system that exists specifically for situations of this kind, Miller left the scene of the crash with her child. The direction she traveled and the location she reached were established by investigators through physical evidence, witness information, and the forensic reconstruction work conducted by law enforcement in the aftermath of the incident. What investigators established was that Miller proceeded to the banks of the Connecticut River and entered the water with her toddler on September 11, 2023. The toddler was subsequently found unresponsive in the water. Emergency response personnel were on scene and provided immediate care, but the child did not survive. The case was referred to the state medical examiner's office, which conducted a thorough investigation into the cause and manner of the child's passing. The medical examiner's finding was definitive. The manner of the toddler's passing was ruled a homicide. This ruling, a medical and legal determination that the child's death resulted from the actions of another person rather than from accident or natural causes, was the critical forensic conclusion that established the foundation for the criminal charges Middlesex County prosecutors filed against Devoni Miller. The charges brought against Miller in Middlesex County Superior Court were serious and specifically tailored to the investigative findings. She was charged with the loss of her toddler's life under Connecticut's most serious criminal statutes, a charge carrying the most severe penalties available under state law, and one that reflects the medical examiner's homicide determination. She was also charged with risk of injury to a child, capturing the circumstances to which the toddler was subjected on September 11, 2023. A charge of reckless endangerment was additionally included in the charging document, reflecting the full scope of the prosecutorial assessment of the conduct the investigation had established. The investigation was conducted jointly by the Connecticut State Police and Cromwell Law Enforcement, with the full involvement of the Middlesex County State's Attorney's Office. The multi-agency nature of the response reflects the seriousness with which Connecticut law enforcement treats cases in which the circumstances suggest that a child's passing resulted from the deliberate actions of a caregiver. Regional news organizations including the Hartford Courant, CT Insider, and WFSB documented the case as it developed and as it moved through the Middlesex County court system. The toddler at the center of this case was at an age of complete dependence on the adult in whose care he had been placed. He had no ability to remove himself from the situation in which he found himself on September 11, 2023. He had no awareness of the river, no understanding of what was happening, and no capacity to seek help. His survival depended entirely on the choices made by the adult responsible for him. The Middlesex County Court record documents what the investigation established about those choices and about the legal accountability that the state determined was appropriate in response to them. Connecticut mental health and crisis intervention services are available around the clock for individuals experiencing psychological distress or crisis situations that may place themselves or others at risk. Crisis intervention specialists emphasize that reaching out for help in a moment of overwhelming distress, before a situation becomes irreversible, is always the right choice. The resources exist, they are accessible, and they are staffed by professionals whose entire purpose is to help. The Connecticut River continues to run through Middlesex County, as it always has. But on September 11, 2023, it became the location of an investigation that changed the lives of everyone connected to this case, and that brought a matter of the most serious criminal significance before the courts of Middlesex County. The toddler who lost his life that day deserved protection. Connecticut's court system is working to ensure that the full measure of legal accountability is applied in his name. Don't forget to like this video and subscribe to Cold Case Hour. Leave a comment and let us know your thoughts on this case. We appreciate every single subscriber, and every comment helps our community grow. Subscribe now. Case 6, Sadie Fleming, Litchfield County, Connecticut, June 9, 2025. Northwestern Connecticut moves at a pace that is different from the state's urban centers. Litchfield County is characterized by rolling hills, small historic towns, and a sense of quiet that is both genuine and deeply rooted in the region's agricultural and colonial heritage. Washington, Connecticut, one of the county's smaller towns, is a community that most people in the state would describe as peaceful, private, and removed from the kind of events that generate law enforcement investigations and criminal court proceedings of the most serious nature. In June of 2025, that description was challenged by a case that brought Litchfield County law enforcement, the State Medical Examiner's Office, and the Litchfield County State's Attorney's Office into a coordinated investigation following the disappearance and subsequent discovery of a mother and her 1-month-old infant son. 1 month old. The victim in this case had been alive for approximately 30 days. He was Sadie Fleming's son, and he was, at the time of the events documented in the Litchfield County investigative and court record, among the most physically vulnerable human beings that the law is designed to protect. A 1-month-old infant cannot communicate other than through crying, cannot move independently, cannot regulate basic physical functions without adult intervention, cannot survive for any meaningful period without the continuous, attentive presence of a responsible caregiver. Connecticut law, and the law of every jurisdiction that takes child protection seriously, treats the circumstances of an infant's passing with the full weight of its most serious criminal statutes precisely because the victim's vulnerability is absolute, and because the adult responsible for that infant's care bears a correspondingly absolute legal obligation. The case began with a report to authorities that Sadie Fleming and her infant son were missing. According to law enforcement records and reporting confirmed by NBC Connecticut and CT Insider, the report of their disappearance initiated a search involving Litchfield County law enforcement and other resources engaged in locating the pair. The search led investigators to a pond in the town of Washington, Litchfield County, Connecticut. What they found there, and what the subsequent medical and forensic investigation established, became the foundation of the criminal case that Litchfield County prosecutors brought against Sadie Fleming. The infant was recovered from the pond. The state medical examiner's office conducted the thorough forensic investigation required to establish both the cause and the manner of the child's passing. The medical examiner's conclusion was that the infant's death was a homicide, a determination that the child had not lost his life as a result of accidental circumstances, but rather as a result of the deliberate actions of another person. This ruling was the critical forensic finding that translated the investigative facts into the criminal charges filed in Litchfield County Superior Court. Sadie Fleming was charged with taking her infant son's life under Connecticut's most serious criminal statutes, a charge that reflects both the medical examiner's homicide determination and the full weight of Connecticut's criminal accountability framework as applied to the deliberate taking of a life, including the life of a 1-month-old infant. She was additionally charged with risk of injury to a child, reflecting the circumstances established by the investigation. The charges were filed in Litchfield County Superior Court, and the proceedings are ongoing at the time this documentary was produced. Because this is among the most recent cases in this series, the events occurred in June of 2025, and the court proceedings in Litchfield County are continuing. The full legal record is still in development. The presumption of innocence applies to Sadie Fleming as to any defendant in the Connecticut court system, and the determination of all relevant facts will be made through the proceedings of Litchfield County Superior Court as the case advances through the judicial process. What is already part of the permanent record is the medical examiner's finding, the charges filed by prosecutors, and the law enforcement investigation that established the foundation for those charges. The town of Washington, Connecticut, and the broader Litchfield County community experienced the particular disruption that comes when a serious criminal investigation unfolds in a small, quiet town. The missing persons report, the search, the discovery, and the subsequent criminal charges created a sequence of public events that the community processed through its local institutions, its civic organizations, and its personal networks. Child welfare advocates in Litchfield County and across Connecticut responded to this case, as they have to others in this documentary, with calls for enhanced awareness, enhanced support systems, and enhanced community attentiveness to the safety of infants in private households. Postpartum mental health support is among the most critical and sometimes most under-accessed areas of healthcare for new mothers in Connecticut and across the country. Organizations specializing in maternal mental health, including Postpartum Support International, maintain resources specifically designed to assist mothers who are experiencing crisis in the weeks and months following childbirth. These resources exist because the medical and mental health community understands that the postpartum period can involve profound psychological challenges that, without appropriate intervention and support, can escalate to crisis. No mother should have to navigate that crisis alone, and the resources to help are available and accessible. The infant son of Sadie Fleming was 1 month old. He had 30 days of life in Connecticut's northwestern hills. The Litchfield County court system is now carrying his case forward, and the legal proceedings will produce, in time, the full judicial reckoning that Connecticut's criminal statutes provide for. His passing is documented. His case is before the court, and the principle that every infant's life carries the full weight of the law's protection, regardless of the circumstances of their family situation or the location of their home, is being applied in Litchfield County Superior Court on his behalf. Don't forget to like this video and subscribe to Cold Case Hour. This content is produced to make sure these stories reach the people who need to hear them. Your subscription directly supports that mission. Hit subscribe now and share this documentary with your community. Case 7, Janita Phillips. Fairfield County, Connecticut. Crime date, June 17, 1986. Case resolved. 2017. The criminal justice system operates on multiple timescales. Most cases move from investigation to charge to resolution within months or, in complex matters, within a few years. But there exists another category of case, one that tests the patience, the institutional memory, and the forensic capabilities of the system across not months or years, but decades. These are cases where the evidence exists, where investigators know that a crime occurred, but where the tools necessary to establish the identity of the person responsible either do not yet exist or have not yet been successfully applied. These are cold cases in the truest sense of the term, preserved, documented, and waiting for the science or the circumstances that will finally allow justice to speak. The case resolved in Fairfield County, Connecticut, in 2017, originating in the town of Greenwich in June of 1986, is one of those cases. It is a case that waited for more than 30 years. And when it was finally resolved, it was resolved through the application of forensic DNA science to evidence that had been carefully preserved through 3 decades of institutional custody in the Fairfield County legal and law enforcement system. Greenwich, Connecticut, is a southwestern Fairfield County community known for its historic character, its proximity to New York, and its position as one of the most affluent towns in the state. It is also a community with a long institutional history and a law enforcement presence that, in June of 1986, responded to a discovery in a local cemetery that would remain one of Greenwich's most enduring unresolved cases for over 3 decades. On June 17, 1986, human remains were discovered in a Greenwich cemetery. The remains were those of a newborn infant, a child who had been alive briefly, whose birth had not been officially recorded, and whose presence in that cemetery raised immediate and serious questions that the Greenwich Police Department and Fairfield County investigators began working to answer from the first day of the investigation. The medical examiner's examination of the infant's remains was conducted with the thoroughness that the circumstances required. The findings were documented and preserved. But in 1986, the forensic technology that would eventually identify the child's mother did not yet exist in the form it would later take. DNA analysis, and more specifically, the application of advanced forensic genealogical DNA techniques to cases involving biological evidence collected at historical crime scenes, became one of the most powerful tools in cold case investigation over the course of the 1990s and the early decades of the 21st century. The development of DNA databases, the refinement of analysis techniques, and the increasing sophistication of the methods used to match biological evidence to known individuals transformed the investigative possibilities available to law enforcement agencies reviewing cold case files. Greenwich investigators, working in coordination with the Fairfield County State's Attorney's Office and with forensic specialists, applied DNA analysis to the biological evidence preserved from the 1986 discovery. According to the court record and reporting confirmed by the Greenwich Time, CT Insider, and the Associated Press, the results of that analysis identified Janita Phillips as the biological mother of the infant whose remains had been discovered in the Greenwich Cemetery on June 17, 1986. The DNA identification was not ambiguous. It was a match of forensic certainty sufficient to support criminal charges and to bring the case, more than 30 years after it was opened, into the active court docket of Fairfield County Superior Court. Fairfield County prosecutors filed charges against Janita Phillips based on the DNA findings and the full evidentiary record assembled from both the original 1986 investigation and the subsequent forensic work that had produced the identification. She was charged with manslaughter in connection with the infant's passing and with concealment of a human body, the second charge reflecting the circumstances in which the infant's remains had been discovered in the Greenwich Cemetery more than 3 decades earlier. The case resolved through a guilty plea. Janita Phillips entered a formal plea of guilty before Fairfield County Superior Court, a plea that created a permanent legal acknowledgement, entered into the court record of Fairfield County, that the events documented by the investigation had occurred as established. That plea, entered more than 30 years after June 17, 1986, brought to a formal legal conclusion one of the longest-running unresolved cases in Greenwich's history. The Phillips case carries several layers of significance that extend beyond the individual facts of the matter. It represents, First and most immediately, the achievement of accountability for a child who had no name, no record, and no advocate other than the law enforcement and prosecutorial institutions that kept the case alive through 3 decades of waiting. It represents, second, the transformative power of forensic science, and specifically DNA analysis, to resolve cases that earlier investigative methods were unable to close. And it represents, third, the commitment of Connecticut's legal system to the principle that the passage of time does not diminish the obligation to pursue justice for a victim, regardless of how many years have elapsed since the original harm occurred. Connecticut has no statute of limitations on homicide and related serious offenses involving loss of life. This legal principle, that the state's authority to pursue criminal accountability in such cases does not expire, is what kept the Greenwich Cemetery case alive through 31 years of unresolved status. The forensic science that eventually identified Janita Phillips was the tool. The legal principle that the case remained prosecutable was the foundation that made the tool relevant. The infant discovered in that Greenwich Cemetery on June 17, 1986, was given no name in life. But in the court record of Fairfield County Superior Court, and in the permanent documentation of the case that was finally resolved in 2017, that child's existence and the circumstances of their brief time in this world are preserved. Connecticut's justice system spoke for that child, 31 years after the discovery that opened the case, and the record of that speaking is permanent. Don't forget to like this video and subscribe to Cold Case Hour. Cases like this one remind us that justice, no matter how long it takes, is always worth pursuing. Your subscription helps us keep telling these stories. Hit that subscribe button now and join the Cold Case Hour community. Case 8, Tiffany Farrauto, New London County, Connecticut, March 7, 2021. New London County, Connecticut, returned to the most serious tier of its criminal court docket in March of 2021 when law enforcement in the city of New London was contacted in circumstances that initiated one of the most significant prosecutions in that city's recent history. The case of Tiffany Farrauto, processed through New London County Superior Court under charges of the gravest magnitude available under Connecticut criminal law, centered on a 4-year-old boy named Liam, and it came to the attention of investigators in part through the actions of the defendant herself. Liam Farrauto was 4 years old. He was at the age that developmental specialists describe as one of the most vibrant and characterful periods of early childhood, an age of imaginative play, of forming meaningful relationships with peers and family members, of beginning to assert individuality and preference while still depending entirely on the adults in his life for safety and care. He was Tiffany Farrauto's son, and he was living with her in their apartment in New London, Connecticut, in the winter and early spring of 2021. On March 7th of that year, Liam Farrauto lost his life inside that apartment. The investigation was initiated when law enforcement was contacted. According to the court record established in New London County Superior Court and reporting confirmed by The Day, the primary regional news publication serving New London County, as well as by NBC Connecticut and CT Insider, Tiffany Farrauto reached out to authorities in connection with her son's passing. The response of law enforcement to that contact set in motion the investigative process that would result in criminal charges of the most serious magnitude being filed in New London County Superior Court. What investigators documented when they responded, and what emerged from the comprehensive investigation that followed, formed the evidentiary foundation of the prosecution against Tiffany Farrauto. The medical examiner's investigation into Liam's passing was conducted with the thoroughness that the circumstances required. The forensic findings of that examination were presented to prosecutors as part of the evidentiary record. According to the prosecutorial record in New London County, Farrauto made admissions to law enforcement investigators regarding the circumstances of her son's passing in their New London apartment on March 7, 2021. Those admissions were specific and addressed the manner in which Liam had lost his life. The medical examiner's forensic findings were consistent with and corroborative of the account contained in those admissions, creating a combined evidentiary record of particular strength and clarity. Tiffany Farrauto was charged in New London County Superior Court with the most serious criminal charge available under Connecticut law in connection with Liam's passing, a charge reflecting both the medical examiner's findings and the admissions made by the defendant to investigators. She was additionally charged with risk of injury to a child. The case proceeded through the new London County court system with the full engagement of the state's attorney's office and attracted significant regional attention given both the age of the victim and the nature of the charges. From an evidentiary and legal standpoint, the Farrauto case is notable for the role that the defendant's own communications played in the development of the court record. Investigators did not have to reconstruct the events of March 7, 2021, entirely from physical evidence and forensic inference. The combination of Farrauto's statements to investigators and the confirming medical examiner findings produced an evidentiary record of clarity that shaped the trajectory of the case through the new London County court system. New London is a city with a long and complex history as a port community and center of maritime culture in southeastern Connecticut. It is a community that has experienced significant economic and social changes over the decades, and it is a community whose residents, like residents in every Connecticut city, include families in a wide range of circumstances, some of them involving stresses and challenges that can, without adequate support and intervention, escalate to crisis. Child welfare advocates in New London County have consistently pointed to the importance of accessible mental health services, family support programs, and community-level awareness of the warning signs that a family may be in a situation requiring intervention and assistance. Liam Farrauto was 4 years old on March 7, 2021. He was old enough to have a personality, a laugh, a way of seeing the world that was entirely his own. He was also entirely dependent on his mother for his safety. The new London County court system has processed his case with the seriousness that a 4-year-old life demands. The court record in New London County preserves both the findings of the investigation and the legal proceedings that have followed, a permanent documentation of what was lost on that March day in 2021 and of the accountability that Connecticut's justice system has pursued in Liam's name. Mental health crisis resources are available in Connecticut 24 hours a day, 7 days a week. The Connecticut 211 helpline connects individuals and families to mental health, crisis intervention, and family support services across the state. If you or someone you know is experiencing a mental health crisis or is in a situation that may place a child at risk, please reach out. Help is available. It is accessible, and it can make the difference between a family that finds its way through a crisis and a tragedy that cannot be undone. Don't forget to like this video and subscribe to Cold Case Hour. Liam's story matters. Your subscription ensures that stories like his continue to be told. Hit that subscribe button, leave a comment, and share this video with someone who cares about justice for children. Subscribe now. Case 9, Sonia Loja. Fairfield County, Connecticut. July 27, 2022. Fairfield County appears in this documentary for the third time, the county's court system and law enforcement institutions having been called upon to process 3 of the cases documented in this series. The Loja case, originating in the city of Danbury in July of 2022, is distinct from every other case in this documentary in a way that matters significantly both legally and in terms of how the public record was ultimately constructed. It is a case in which the investigation documented a tragedy of enormous magnitude, the passing of 3 children, but in which no criminal prosecution could proceed because the person investigators identified as responsible was herself no longer living at the conclusion of the investigation. Danbury, Connecticut, is located in northern Fairfield County and is one of the most diverse cities in the state. Its population includes a substantial and long-standing immigrant community, and its social fabric encompasses a wide range of cultural backgrounds, languages, and community institutions. It is a city with an active social services network and a law enforcement agency experienced in responding to the full range of situations that arise in a diverse urban environment. On July 27, 2022, the Danbury Police Department responded to a residential address within the city following a report that resulted in one of the most significant and sorrowful investigations in the department's recent history. When law enforcement entered the residence, they discovered 3 children who had lost their lives. The investigation that was immediately initiated involved the Danbury Police Department and the Connecticut Office of the Chief Medical Examiner, which conducted the forensic investigations necessary to establish both the cause and manner of each child's passing. Those investigations were thorough, methodical, and produced findings that were documented with the full precision that the medical examiner's office applies to all cases of this nature. The 3 children who lost their lives in that Danbury home on July 27, 2022, were the children of Sonia Loja. The medical examiner's investigation into each child's passing established the manner of death as homicide, a medical and legal determination that each child's life was ended as a result of the actions of another person. The investigation further established that Sonia Loja, the children's mother, had passed away at the scene. The manner of her death was determined to be a self-inflicted act. The legal classification that applies to this type of event, where a person causes the deaths of multiple family members before losing their own life, is familicide followed by suicide. Because Sonia Loja was deceased, Connecticut law provided no pathway for a criminal prosecution to proceed. There is no living defendant to bring before a court. There is no trial, no sentencing, no judicial accountability in the conventional sense. What exists is the investigative record, the findings of the Danbury Police Department, and the Connecticut Office of the Chief Medical Examiner, preserved in the permanent documentation of the Fairfield County legal and public safety system. The absence of a prosecution does not reduce the significance of this case for the Danbury community or for the broader conversation about child welfare, mental health, and family crisis intervention in Connecticut. If anything, the Loja case, precisely because its outcome foreclosed the possibility of conventional judicial accountability, has prompted a more sustained and more searching public conversation about the systems that existed or did not exist to reach this family before July 27, 2022. Danbury's community organizations, mental health advocates, and social service institutions engaged seriously with that conversation in the months following the events of July 27. The questions raised were not simple ones. They involved the availability and accessibility of mental health services to immigrant communities in Connecticut, including the linguistic and cultural barriers that can make standard crisis intervention resources difficult to access for individuals whose primary language is not English and whose relationship with government institutions may be shaped by experiences very different from those of the broader population. They involve the role of community networks, neighbors, extended family, faith communities, cultural organizations, in identifying and responding to signs of severe psychological distress in a family member. And they involve the question of what interventions, if available and accessible earlier, might have produced a different outcome. Connecticut has invested in expanding culturally and linguistically accessible mental health and crisis intervention services in communities with significant immigrant populations. Organizations including the Danbury-based Latin American Affairs Commission and regional chapters of the National Alliance on Mental Illness maintain resources specifically designed to reach community members who may face barriers to standard crisis services. These resources represent a recognition that effective crisis intervention must meet people where they are, culturally, linguistically, and geographically, if it is to have the chance of reaching a family in need before a situation becomes irreversible. The 3 children who were found in that Danbury home on July 27, 2022, were individuals. They were children who had formed relationships within their family, their neighborhood, and their community. They had futures. The investigative record that the Danbury Police Department and the Connecticut Office of the Chief Medical Examiner produced in connection with this case is the permanent official documentation of their passing and of the full effort of Connecticut's investigative institutions to establish the truth of what occurred. That record is their legacy in the public archive, and the ongoing community conversation about mental health access and family crisis intervention that their case has helped to sustain is, in its own way, a form of accountability, a commitment by the community around them to ensure that what happened in that Danbury home on a summer day in 2022 does not happen again, if any human institution has the power to prevent it. Don't forget to like this video and subscribe to Cold Case Hour. These 3 children deserve to be remembered. Your subscription is one of the ways you can help ensure that their story reaches people who need to hear it. Leave a comment below. Hit that subscribe button now. Case 10, Kimberly Sullivan. Litchfield County, Connecticut, February 14, 2004. Litchfield County concludes this documentary series, and it does so with a case that, in its legal framework and its investigative approach, addresses one of the most important and sometimes least discussed areas of child welfare law in Connecticut. The case of Kimberly Sullivan, prosecuted in Litchfield County Superior Court following the investigation of events in Torrington, Connecticut, in the winter of 2004, is a case built not on a discrete act occurring at a single moment in time, but on something that investigators and prosecutors find in some ways more difficult to prosecute, and in some ways more systemically significant: prolonged neglect. The sustained failure of a caregiver to provide the basic conditions necessary for a child's survival. Torrington is the largest city in Litchfield County, a city with a manufacturing history in the Naugatuck River Valley and a working-class character that has defined it through multiple generations of economic change. It is a community with schools, churches, neighborhood associations, and the kind of social infrastructure that, in its best functioning, creates the conditions for awareness and response when a family is in crisis. The events that led to the Kimberly Sullivan prosecution originated in a private residence in Torrington during the winter of 2004, in circumstances that investigators determined had been developing over a sustained period of time. The victim in this case was a child in the care of Kimberly Sullivan. The investigation conducted by Torrington law enforcement and the Litchfield County State's Attorney's Office documented the conditions in which that child had been living and the standard of care that had been provided, or more precisely, the extent to which that standard of care had not been met. What investigators found, and what was subsequently translated into criminal charges in Litchfield County Superior Court, reflected a sustained pattern of neglect and the maintenance of unsafe conditions over an extended period. The child's passing was the direct consequence of those conditions, as established by the forensic and investigative record. Sullivan was charged with manslaughter, risk of injury to a child, and criminal negligence. Each of these three charges addresses a distinct legal dimension of what the investigation established. The manslaughter charge reflects the finding that Sullivan's conduct, her sustained failure to provide adequate care in conditions that were dangerous and ultimately fatal, constituted the kind of reckless disregard for human life that meets Connecticut's threshold for criminal accountability in connection with the loss of life. The risk of injury to a child charge documents the conditions that existed in the residence and the ongoing exposure of the child to harmful circumstances. And the criminal negligence charge captures specifically the dimension of Sullivan's conduct that represents a gross departure from the standard of care that a reasonable adult in her position was legally required to exercise. The three-charge framework in this case is characteristic of how Connecticut prosecutors approach cases of prolonged child neglect that result in a child's passing. Unlike cases built on a single act, neglect cases require prosecutors to establish a pattern, to document the conditions over time, to connect those conditions causally to the child's deteriorating health and ultimate passing, and to demonstrate to the court that the defendant's role in creating and maintaining those conditions meets the legal threshold for each charge in the indictment. This evidentiary work is painstaking and requires the collaboration of law enforcement investigators, medical professionals, forensic specialists, and child welfare experts. The Torrington law enforcement community and the Litchfield County State's Attorney's Office conducted that collaborative work in the Sullivan case with the thoroughness that a child's passing demands. The case was brought before Litchfield County Superior Court and is preserved in the court record of that judicial district as a documented instance of Connecticut's criminal justice system applying its statutory framework to a case of criminal neglect with the full seriousness that such a case warrants. Cases of prolonged child neglect occupy a particular place in the landscape of child welfare advocacy and public policy. They are, in many respects, the cases that child safety systems are most specifically designed to detect and interrupt before they reach the point of irreversible harm. The existence of mandatory reporting laws in Connecticut, laws that require teachers, medical professionals, social workers, child care providers, and other professionals who work with children to report reasonable suspicions of child abuse or neglect to the appropriate authorities, reflects a legislative recognition that early detection and response are the most effective tools available for protecting children from the consequences of sustained neglect and unsafe living conditions. The child in the care of Kimberly Sullivan during the winter of 2004 in Torrington, Connecticut, deserved better. That child deserved warmth, food, safety, and the attentive care that the law required. The Litchfield County Court Record documents, in the permanent and precise language of Connecticut's criminal justice system, what the investigation established about what that child received instead. The 3 charges filed against Sullivan in Litchfield County Superior Court represent the state's formal legal response to those findings. A response grounded in the principle that every child in Connecticut is entitled to the protection of the law, regardless of the circumstances of their household, the economic status of their caregivers, or the private nature of the setting in which they are living. Connecticut's courts have processed the Sullivan case as they process every serious criminal matter, with the application of established legal standards, the careful evaluation of evidentiary records, and the consistent application of the principle that accountability is owed to every victim. Litchfield County's court record is one entry in the broader record of Connecticut's commitment to that principle. And this documentary series, 10 cases across 6 Connecticut counties, is a documentation of that commitment across the full range of circumstances that bring serious child welfare cases before the state's courts. Closing, Cold Case Hour. 10 cases. 10 children. Hartford County, New Haven County, New London County, Middlesex County, Litchfield County, and Fairfield County. 6 judicial districts across the state of Connecticut, each of them processing cases that carried the most serious weight available under the state's criminal statutes, each of them building records that will endure in the permanent archives of Connecticut's court system for as long as those archives exist. The children in these cases, Jacqueline Torres Garcia, known as Mimi, Elijah Ziolkowski, the 6-week-old infant son of Crystal Czyzewski, the 2-year-old son of Tabitha Frank, the toddler son of Devoni Miller, the 1-month-old infant son of Sadie Fleming, the unnamed newborn found in a Greenwich cemetery in June of 1986, Liam Farrauto, the 3 children of Sonia Loja, the child in the care of Kimberly Sullivan in Torrington, each of them an individual, each of them a life, each of them deserving of the protection, the care, and the safety that every child in Connecticut is entitled to by law and by the basic moral obligations of the communities in which they lived. The Connecticut criminal justice system, across these 10 cases, has demonstrated a consistent commitment to pursuing accountability when a child's life is lost within the state's borders. That commitment is not perfect. No human institution is. But it is serious, it is documented, and it is sustained across jurisdictions, across decades, and across the full range of circumstances under which these cases arose. Thank you for watching every case in this documentary. Thank you for caring about these children and about the work of the Connecticut courts that have carried their cases forward. And thank you for being part of the Cold Case Hour community. Please like this video right now. Please subscribe to Cold Case Hour and hit the notification bell so you are always the first to know when a new documentary drops. Please share this video with someone in your life who cares about true crime, about justice, and about the safety of children. Every like, every comment, every share, and every subscription directly supports our ability to keep producing this content. These children are counting on us to make sure the world knows their stories. Don't forget to like and subscribe. We will see you in the next case.